Alright, Indiana Administrative Rule Policy Title 3112, Title 312 Natural Resource Commission, Article 29 Oil and Gas. Rule 3, General Provision, Section 1, a division shall prepare the forms required under the article. Servability of the rules and if any word of the phrase of the sentence of the portion of the rule under the article declared invalid, the declaration shall remove the remaining portion of the parts of the rules article. Waste prohibited. Owner of the operator shall not commit to the waste found but not permitted waste for the pumping and placement of the fluid well stimulation conducted in accordance with the Indiana Code 1437 of this article of the burning of natural gas flares located safe of the difference well while the owner and operator of the well producing both oil and natural gas if not economical to market with the natural gas for the burning of the coal bed methane flares located with the safe of the distance from coal bed methane well by the owner and operator of the coal mine designate with the owner of the operator coal mine and either of the both of the following comply with the burning necessary for the protect with the coal miner's safety is not economical to market with the coal bed method in informal hearings upon with the request for the effect of the person of the division shall conduct with informal hearing consider any part of the justice of the administrative Indiana Code 1437 of the article include with the following request amendment with the repeal of the rule of this article with the request relating to issuing with the reissuing of the modification revocation permit with the oil and gas and purpose of the request exemption of the drilling unit spacing requirement of the request is relating with the review of the pending of the petition aquifer exemption 312 Indiana Code 2916 with the request for the integrating interest of the drilling unit with the Indiana Code 1437 and 9 or is in separate interest they have another graded integration of the issue with the notice of violation if the section prohibit the division of the holding and authorization formal hearing its own initiative with the consider of the matter with the assist of the administration with the Indiana Code 1437 in this article with the informal hearing under this article should be conducted by the division director and authorized representative of the division of the director may with a facilitate public participation with the gathering of information relevant to the matter under consideration. Informal hearing is not governed by the rules of evidence of the discovery the division shall provide with a notification first class mail with a application both of reasonably calculated with an informed affected person for the time and place and purpose of the hearing and the notification informal hearings considered the class 2 well permit or permanent application shall provide the same purpose identified in Title 312 Indiana Administrative Code 2952 within 30 days of the following conclusion informal hearing the division of the director of the authorized rep of the division of the director for the written finding issue or of the disposition of the matter with a copy of the order of result of the informal hearing shall include instructions seek with administrative review in Indiana Code 4215 this is by send with the first class of the mail to each person notified according to the subsection D when who participated in informal hearing reasonably noted to effect by the order of the publisher and the division website and order resolved of the informal hearing under the article of the subject of the administrative review under Indiana Code 4215 and in 312 Indiana Administrative Code 31 except the order with respect to the rule of adoption and subject to the review at Indiana Code 4222. Notice of the approval of denial of applications unless otherwise specified the notice of the division action and over the application submitted to Indiana Code 1437 in the article shall provide with the application to each of the person filed with the objections to the applicant each for the person participating in formal hearing relating to the application and any other affected person including instructions seek for the administrative review under Indiana Code 4215 with the considerable and confidential information upon written request for the operator following the information shall have the confidential by the division period of 1 year of the day of the completion of the oil gas strip of the drill of the log of the completion report, including all completion information accompanied with the completion of the report, geological, physical instrumentation, log, drill cutting in the curve of the well production information submitted in accordance with 312 of the Indiana Administrative Code 2925.1. Rule 4, permanent and transfer procedures all well with any of the person may not drill deep in the operator of the converted well with the oil gas purpose without the permanent issue of the division in Indiana Code 1437 in this article. No person may with the commence of the drilling construction operation conversion of the class 2 well except for the conformance with this article with the original copy of the permit must be posted over the end of the operator well site with before drilling the deepening and the operating of the well with the permit application of the rule of the established general application requirements of the permit drill deep and operate convert with the well oil gas strip of the application and permit with the drill with the deep and operate with the convert well oil gas with the ship with the with the form described with the division permit application must be signed by a person with the designated with the application or as a person who with the control of the well with the oil gas perfectly upon with the request of division with the authorized representative whether signed with the behalf of the owner with the operator with the furnished with the satisfactory evidence with the authority. Application shall remove the application permit within $250 and with the cash about a check with a draft or with a payable to the appointment the person may apply with the expedited review of the applicant with the permit with except for the class 2 with a non-commercial well by submitting a permit fee of $750 with the application must be accompanied with a survey certified with the professional certified register of the Indiana Code 2521.5 showing showing with the location proposed well with the oil and gas purpose given quarter section of the township, the range and county with the lot number, the footage of the well with the survey lines of the block with the recorded plot with the land is plotted 3 of the nearest boundary lines to the track with the distance with the 2 direction corner of the track of the land upon which of the wells drilled with the form of the newest quarter of the post of the lower lot corner, universal transmessiator of the coordinates, a coordinate with the 4 meters of the actual surface location of the ground with the horizontal drill and horizontal directional well with additional requirement subsection E with the survey with the certified with the professional survey registered with the Indiana Code 2521. 5 shall include the following surface location at the bottom of the whole location footage of each of the point survey lines, the location in which each of the horizontal drain holes into the part of the target zone with the footage of each of the point with the survey line, the bond with the required with the 312 of the Indiana Administrative Code 2912. 3 with a must accompany with the permit application demonstrate that ownership of the mineral ownership of each of the applicant with the permit of the Indiana Code 1437 of the name of this article may show with the following property information survey required in section 10E of this rule. Drill of the unit boundary of each of the oil gas production boundary, each of the property to leave the continues of the drilling unit in which of the applicant claimed for the right to drill with the operator of the well oil gas purpose, the boundary of the area with the incorporated with the into common ownership of the control of the drilling unit, the compromise separated with the oil and gas interest owner of the boundary of the enhanced recovery unit with the pool production unit. If the well is part of the enhanced and covered recovery unit or pool production unit, well is proposed to include with the new enhanced recovery unit with the pool production unit with the location each of the house, barn, building, structure, other defenses located within 200 feet of the well. Application shall include the statement that the applicant owner with the control of the right to drill with the operator with the produce the well oil gas purpose with the property within drilling unit with the well surface owner with the notification intent with the survey with the application over the well with the oil gas purpose and may include with the name of the address of the owner of the property which the well is located reflect with the county tax duplicated record last known address of the most recent owner shown in the county transfer book. Application shall provide with the proof of the owner and property of the well located with the receipt of the note required by the Indiana Code 322376.5 with the following acceptable demonstrator of the proof of the service owner notification, certified mail or receipt with a company with a copy of the written notification of landowner, written statement of the service owner, acknowledgement of the receipt of the notification, copy of the written agreement with the service owner, differential notification from the company with the written verification of the provided in accordance with agreed upon terms for was permitting the well of the 1/2 mile with the gas petroleum storage reservoir, applicant of the well oil gas produced and with a drill within 1/2 mile of the underground gas storage facility, underground petroleum storage facility shall not be approved except in accordance with the requirements of 312 of the Indiana Code, Administrative Code 2918. Applicant requirements of the well incorporated boundary of the city of the town. The permit application for the well of the oil gas permit produced of the drill within the incorporated boundary of the city of the town must be accompanied with a certified copy of the official consent of the drill by ordinance of the municipality legislative body with approval of the denial of the well permits. 7A. With except for the provided subsection B, with the applicant with the permit comply with the Indiana Code 1437 in this article, the division shall issue with the permit. The division must deny the permit application if the applicant with the person owns with the control of the applicant has been issued with a notice of violation, failed to debate the violation within 60 days after the date of the abatement, unless the person requested the administrative injunction with the notice of violation of the final determination not rendered with the convention. Control of any well the oil gas purpose demonstrated with a pattern of the violation in Indiana Code 1437 in the article with the result of the damage to the environment or has permit revoked in Indiana Code 1437. For the permit application does not meet the requirement in Indiana Code 1437 in this article with the division shall notice for the incomplete with the application along with the applicant 30 days to correct for the deficiency. Feel the correct the deficiency will result in the division denial of the application. Division should issue with a notice of decision to approve of the denial of the permit application with the accordance with 312 of the Indiana Administrative Code 2935. The decision shall approve of the denial of the permit application well with the oil gas purposes subject to the Indiana Code 1425. 21.5 of the division shall publish the list of the permitted decisions with a website but not less frequently than once per week with including instruction of the obtaining of the copies of the well permit application. Permit modification amendment, but the divisions may require with the modification permit over the well for the oil gas purpose of any of the following causes of the person controlling the well for the oil gas purpose of course for the degree of the modification of the material within substantially alteration or addition of the permitted facility or activity occurred with the permit issuing with the justifying of the modification of original permit. The permit has received the information cumulative of the effects of the environment or the resulting of the permitted well were unacceptable in Indiana Code for the article chain with the amendment by the chain with the law of the form basis of the approval of the permit application. The division director of the determined the good cause requirements exist for the modification compliance schedule for the control of the vents, which will the person with controlling the well oil gas purposes has little no control with no other remedy impracticable. Good cause exists for the revocation or the permit over the 312 of the Indiana Administrative Code 2934 by the division director of the modification properly to fulfill purpose of the Indiana Code 1437. The person controlling the well of the oil gas purposes made before the drilling commencement file with the amended permitted application. Original permit attached with the sheet of the chain with the well location division may issue with the amended permit with the modified well placement would be located with the original lease. There's none effect for the person who have the entitled with the notification modification location that included with the original permitted application who has now been notified with the original application and does not significantly change how the person entitled with the notification would be effective. The division shall issue with the notice of the decision approve of the denied permanent modification application according to the 312 of the Indiana Administrative Code 2935 of the decision approve of the denied of the permit modification application subject to Indiana Code 421.5 permit duration. A permit drilling of the new well with the oil gas permit expires 1 year of the day of the issuing of the drilling of the well has commenced with the permit authorizing the operation water and the oil gas permit for the effect of the life of the well so long as the well is operated within accordance with the Indiana Code 1437 and the other cold terms permanent unless the permit revoked and expired with the otherwise terminated in this chapter. Permit transfer for the section of the established requirement for the transfer of the permit issue for the division of the well and oil gas permit for the permit's control of the well and oil gas permit to provide advance notice of the division intention of the transfer of the permit to another person. Applicant permit transfer shall be completed with the form described by the division following when it may be submitted with the application permit transfer the bond of the transfer of the required in 312 of the Indiana Administrative Code 2912.3 a fee of $15 payable to the department within 50 applications for the permit to transfer with the submitted simultaneously. However, the applicant submits more than 50 applications for the permit transfer simultaneously. The application fee for the applicant excess of $50 to excess of $50 is $10. The department shall grant with approval of the application of the permit transfer with except upon written finding with the set for at least one of the following factors with respect for the person who will control of the well, oil, and gas permit the following the transfer of the permit fee required. This section not submitted bond transfer but not submitted if required in 312 of the Indiana Administrative Code 2912.3 the transfer of the person controlling of the well, oil, gas permit for the transfer of the demonstrator of the pattern willful violation in Indiana Code 1437 the article in this article resolve the damage of the environment the transfer of the person controlling of the well, oil, gas permit again. So there is pending notice of violation or civil penalty under 312 of the Indiana Administrative Code 2934.3 with the finding of the made however the transfer of the not disqualified the reason the transfer if violation has been or process of being corrected satisfaction division of the director transfer has over the present leave of the pursuing with administrative review of the violation Indiana Code 421.5 of the transfer has permitted revoked in Indiana Code 1437 and if the applicant fitted with the transfer of the permit with the pending of the notice of the violation if the person controlling the well, oil, gas purpose against the violation issue with the surety with the liable to perform abatement with the violation satisfying with the assessed penalty with the transfer of the permit with the may accept the liability performing abatement of the violation but not liable to satisfying with any existing excess assets penalty transfer of the permit liable to the abatement of the violation identified with any of the penalty and excess after the transfer of the permit the division director may within the writing of the waive of the penalty would otherwise apply with the during the period with no more than 90 days following with the transfer of the permit the division director determines of the transferee is acting with a good faith with the corrective violation no further permit is issued with the oil and gas purpose of the fact until the transfer is approved with the writing by the division director the division shall issue notice the decision approved and denied with the applicant to transfer of the permit in accordance with the 312 of the Indiana Code Administrative Code 2935 and the decision approved and denied with the application for permit transfer under subsection Indiana Code 421.5. Rule 5, additional permanent requirements for Class 2 wells. Class 2 well application of the rule established permits the requirement of Class 2 well addition of the requirements of 312 of the Indiana Code 29.4 with additional requirement of 312 of the Indiana Code 29.4 with the applicant permitted converting an existing with a well drill with a construction class 2 with it must be accompanied with the following well surveyed in 312 of the Indiana Administrative Code 29.4.2 with the E with the mass include with the permanent number, location, and depth of each of the well, oil, and gas purpose with any of the well, but including an abandoned with the non-operational well with the penetrate with the injection formation production zone. Each water well recorded with the Department of Indiana Code 2539 1.5 located with the area review of the proposed Class 2 well with the information well with identified subsection matter of the public record with the information shall have then known with the applicant regarding with the wells must include with the under the subsection evidence of the well on the subdivision 1 shall contain with the adequate amount with the cement with the construct with the plugged in with the manner with the prevent with the injection fluid with the fluid injection formation and entering with the underground source of the drinking water the type of the evidence with the consider with the acceptable where the division include but are not limited to well completion records cementing records of the well construction records reports, amending bomb logs, tracer surveys, oxygen activation logs, plugging record of determinations made with the division with the well area within the area with the review does not contain the adequate amount of some inadequately constructed or plugged. The applicant should submit with either the following documented demonstrate with the injection fluid used with the Class 2 well with the formation will not cover the contamination underground source of the drinking water. Applicant intended to submit with the evidence of the fluid level of measurement at any of the well area of the review fluid level of measurement will witness oil gas inspect with the corrective action plan with the describe of the measurement will take with the well area with the review and ensure that the well will not serve the conduit mitigation fluids into the ground source of the drinking water if approved by the division correction action plan and incorporated as condition and permit for the Class 2 well with a schematic diagram of the proposed Class 2 well showing the following total depth of the plug black of the well, if any, with the depth of the injection disposal interval, geological name and injection, the disposal zone with the geological name, thickness, and the description of the confining zone, vertical distance and separating uppermost extremity with the injection zone for the basement of the lowest underground source of the drinking water, depth of the top of the bottom of the casing of the cement used using the well, the side of the casing of the tube, with the depth of the packer, depth of the basin, lower most underground source of the drinking water, if the well is originally drilled for the purpose of the other Class 2 wells, a copy of the completion report with the available geological, physiological of the well, formation of the interval for the of the U of the disposal, the capable of the producing oil gas application, including in the demonstration of the U of the interval disposal of the non-concept with the waste proposed operating depth of Class 2 wells with the geological name of the depth of the location injection fluids or for the enhanced recovery well with the description added for the other than produce the fluids over the probe with the inject with the channel laboratory and for the representative samples of the fluids injected into the proposed Class 2 permit location description of the underground source of the drinking well through the well would have the description of the current proposed casing program including the following casing size with weight and the depth of the type of the cement volume and the type packer and type of the setting the depth of the type of the completion of the well proposed method for the testing casing of the proposed maximum injection rate pressure for the maximum allowable the injection pressure for that the well head should be less than the pressure with which initiate the new fracture of the propagate with the existing fracture confining with the zone due to the underground source of the drinking water and with the chaos of the movement of the injection fluid with the underground source of the drinking water the maximum allowable the injection pressure will determine one of the following methods immediate shut-in pressure over the base of the well treatment of the report with less than 10 years of the uppermost injection zone with the maximum allowable the injection pressure will have the value with 90% of the immediate shut-in pressure less than 14.7 psi separate with the test pressure of the method the upper injection zone with the maximum allowable the injection wellhead with the value with 90% of the lower breakover pressure with the maximum pressure reached during the test less than 14.7 psi with the pressure calculation formula maximum allowable the injection pressure over the wellhead for the determinant corner for the following and P max maximum injection pressure is equal to 0.8 psi over feet minus 0.433 psi over feet over the SJ specific gravity injection fluid to the depth of the top of the uppermost injection zone feet. For an alternative method approved by the division director based on the technical lab that can be demonstrated if they do not initiate with a new factor confined zone application potential affected parties. Applicant with a Class 2 well with a model strip with a written notification describe the proposed well with a person and personally with a certified mail to each of the following person with a describe of the property located 1/4 mile of the proposed Class 2 well to each person who with control of the well oil gas with include with the wellhead with a temporary abandonment status of the 312 of the Indiana Administrative Code 2933 well oil gas with not yet with the production unexpired permit over the drill with the oil gas with the permit with the underground mine permit with the Indiana Code 1434 with the person who filed within 312 of the Indiana Administrative Code 2917 1C with showing the location of the commercial mineable coal research each for the person with the control of the underground gas storage, the underground petroleum storage reservoir identified in 312 of the Indian Administrative Code 2918-1. Each person have a service of the property interest of the notification required within subsection A with the specified with the person within 15 days with the receipt of the notification show for the written with the comment request informal hearing before the division of 312 of the Indian Administrative Code 2934 with the notification show include with the address for the written submitted for the hearing request with the forwarded where additional information was with include with the instruction of the name of the copy of the application. If the addition of the notification required within subsection A of the applicant shall cover the notice of the permit application placed in the newspaper journal circulation in the county where the proposed well is located. The notice must include the name and the address of the applicant with the location proposed well with the lease of the name of the well, the number of the proposed well, geological, the name and the depth of the intervals, injection zone, and the maximum injectionable pressure of the property, proposed maximum rate of the barrels. Each day of the notice shall specify the person within 15 days of the publication of the notification subject written comment of request informal hearing the division 312 of the Indiana Administrative Code 29 2934. Notification shall include the draft of the written comments. The hearing request must be forwarded to how the person written know of the proceedings, how additional information concerning the person proposed permit can be obtained with evidence, even notice served with the subsection any of the evidence publication notice under the subsection C with the included in part of the application. Modification of Class 2 permit with the owner of the operative of Class 2 well should with the submit with the application change with the permit condition you with the form prescribed with the division of chain with the injection zone additionally adding injection zone chain with the maximal allowable injection pressure chain with the maximal allowable injection rate with the permitted Class 2 well. Notice for the request modified with the operator of the permitted Class 2 well under the section shall be provided with according to the requirements of Section 2 of this rule with a copy of the notice and proof of the notification accompanying with the application to modify the operation Class 2 permit and notification proof of the denial of the Class 2 well permit. Section 4. No permit shall be issued to the denial of the Class 2 well until the delay of the 18 days of the service of the notification under the subsection 2 of the rule proof of the service of the notification published affidavit of the newspaper publications made with the division director issuing with the determination following informal conducted accordance with the 312 of the hearing Indiana Code 2934 of the section version shall issue with the notice of the decision approval of the denial application for the existing well of the Class 2 well, the drill construction Class 2 well, modified Class 2 well permit in accordance with the Title 312 of the Indiana Administrative Code 2935 of the decision approval of the Class 2 with the well permit application of the applicant modified Class 2 well subject to Indiana Code 4215. Rule 6 additional permit requirements of coal bed methane well. The rule establishes the permit requirements of coal bed methane wells and additional requirements of 312 of the Indiana Administrative Code 29.4. Additional permit application requirements of the coal bed methane wells. The application for the coal bed methane well permit include the detailed plans of the following well stimulation operation information as follows. The source of the proposed volume of the base flow to be used in the description each additive proposed included well stimulation program including the following produce rate of the proposed rate of the concentration added of the production product name of the identified with the manufacturer material safety data sheet with the description type of the purpose of each of the additive with the copy of the material safety data sheets for each of the additive product well stimulation design information such as the identification each of the coal seam simulated of the proposed casing and cementing of the plan of the well the identification principle described with above with below each of the coal seam and the anticipated surface of the trading pressure range maximal injection trading pressure for the face and above with the clear of the orientation of the dome of each of the coal seam and the estimated calculated fracture of the half length of the fracture height is known with the demonstrated of the coal seam outside of the coal bed methane production as our will not advisedly affect the hydrofracturing operation with adequately protected future underground mining of the plan with the flushing of the fluids with the well flowing completion of the well stimulation operation including the management of disposal of the flow back fluids and solids. In addition, with the requirements of Subdivision 1 hydraulic fracturing occurred with the proposed applicant must identify with an unknown water well, but including water well that identified with the online water well record database of the Department of Division over the water known wells, oil and gas for the test over the boring of the well penetrated with the coal seam and the hydraulic fracture with they are located with a greater distance of the radius of the 500 feet of the estimated calculated fracture half length over the proposed coal bed methane well. If the wells are oil gas stuffed over the borings identified in Subdivision 2 of the division, determine the significant resistance over the conduity with the migration of the fluids underground source of the drinking water. Division director may require applicants to perform the remedial plugging operation, take other reasonable measures, including modifying with the hydraulic fracturing plan and necessary with the minimize to eliminate the adverse impacts of the underground source of the drinking water as a result of hydraulic fracturing operation. In written consent of the drilling of the coal bed methane well cannot be obtained with the coal owner with the coal leaser with the required under Section 581 of this rule. In addition, with the proof of the notification required under Section 582 of this rule, applicant must submit an affidavit to certifying with the upon with the diligent inquiry with the activity of the applicant with respect with the drilling, completing and operating and abandoning of the coal bed methane will not result with the waste of the commercial mineral coal resource, would not endanger health and safety of the underground coal miners as believed within the subdivision. Diligent inquiry includes a reference of the record filings maintained with the department made by the coal owners and leasers under 312 of the Indiana Code Administrative Code 2917-1 with the public available records pertaining with the thickness and depth of the coal with regard to the commercial mineable coal resources 312 Indiana Administrative Code 2917-2. Horizontal coal bed methane well applications. Horizontal coal bed methanes are proposed with completed commercial mineable coal resource for the applicant must include the following information. Proposed length and orientation each horizontal drain hole with the measure would be an extension of the drain hole that does not deviate with the strata of the above or the below of the coal seam. Unless the coal owner or the coal leaser gave the written consent of the Indiana Code 1437-4.85 with D2 with a plan with a plugging and abandoning with a horizontal drain hole with a portion of the well abandoned over the well for insufficient information demonstrated with the division direct for the method of the material with the waste commercial mineable coal resource sold strip of the coal ownership of the information from the applicant with the coal bed method will permit with the include with the name of the address of the following strip of the owner of the property well located with the reflect for the county with the tab duplicate relic the last known address of the most recent owner shown county transfer broke with the owner of each of the coal seam through which the applicant well will penetrate with any of the lease of the coal seam through the applicant well will penetrate. Proof of notification co-ownership with the written consent with the applicant with the coal methane well permit must include with one of the following with written consent with the drilling with the coal bed methane well from any of the coal owner with the coal lease identified in section 4 of this rule. Proper proof of the notification applicant intent with apply with the coal bed methane well permit to coal owners with the coal lease with identified under section 4 of this rule. Proof of the notification coal owner with the coal lease with the demonstrator with the certified mail with the company with copy written notification coal owner with the coal lease with the written statement with the coal and coal lease with the acknowledging of the receipt of the notification coal subject with the lease with the written consent and with the provide with the coal owner with the coal lease and with the subsection A1 must include with the statement including in the recovery of the coal bed methane rolls over the waste of the commercial mineable coal resource if the coal is not subject to the written consent with the provide with the coal owner and subsection A with the one must include with the statement that the coal owner is not leased the coal with the coal mining purpose of acknowledging of the recovery of the coal bed methane rolls over the waste of the commercial mineable coal resource. Request to receive the notice of filing when the coal bed methane application of the person with the interest in the mining of the commercial mineable coal resource may request the notice each of the complete application of the coal bed methane well permit filed. Person may receive the notice under the section of the subwritten with the request include with the following with the name and the title of the mailing address, the email address, the telephone number of the person to whom the notice shall be sent, the name of the county with the counties for the interest of the proper public notification of the receipt of the complete coal bed methane. This section establishes a requirement that notifying with the potential for the effect of the person with the filing with the completed application for the coal bed methane well permit of the filing with the components of the comments of objection of the issuance of permits of the coal bed methane wells. Upon determination, applicants substantially completed with the 312 of the Indiana Code for this rule, the division shall with the notice of the coal bed methane permit application for the website shall include the following permit application data signed with the application name and name address of the applicant, lease name of the well number, the well type of the located proposed well by section township of the range and county. Proposed depth of the well and coal but seems effective the instruction obtained with a copy of the permit application and instruction of the following objection, including the deadline with the submitting of the comments to objection section 8 of the rule within 15 days of the applicant with a determined substantial complete under the rule of the 312 of the Indiana Administrative Code 29.4. The division shall be written with the notice for the coal methane permit with the application filed with each of the person receiving the request, receive the notice under section 6 of the rule owner of the coal owner coal lease with the other person with the interest of the developer and coal resource of the file with the affidavit division Indiana Code 1437.7 and 8, 312 Indiana Administrative Code 29.17 1A3 with the surface owner of the property with the coal bed methane located with the notification provided under subsection C, which shall include the following permit application date and signed with the application and with the name of the ref of the applicant, leasing the name and well number, the well type of the located proposed well by section township of the range and county, proposed depth of the well, coal seams affected, instruction obtaining the copy of the permit application, instruction following comments, objections, include the deadline submitting with the comments for the objections under section 8 of this rule. Alright, filing comments with the objection of the coal bed methane application of the permits, filing with the written comments for the objection of the request for the informal hearing related to the coal bed methane permit application 30 days for the publication required in subsection 7B for this rule, 30 days for the day of the affidavit, the notification letter of the person receiving the notice according for the subsection 7C of this rule, of the approval of the denial of the coal bed methane permits. A decision approval of the denial of the coal bed methane will permit the application of the Indiana Code 421.5. The notice for the approval of the denial of the coal bed methane permit of the division shall the notice of the decision approval of the denial of the coal bed methane permit application according to 312 of the Indiana Administrative Code 29.35. In addition, with the issue of the notice for the permitted decision of 312 of the Indiana Code 29.351, division shall issue the notice for the permitted decision. Each person is for the notice of the under the section 7C of this rule. The person will be filed with the division written comments and objection with the request and formal hearing in section 8 of this rule. Notice of the permitted decision instruction of the requesting administrative review of the Indiana Code 421.5 will be posted with the division with the website within 3 working days of the filing with approval of the denial of the permitted rule 7 of the additional of the permanent requirement of the non-commercial wells. Section 1 of the rule establishes permits required with the non-commercial well with the addition of the requirement of the 312 of the Indiana Administrative Code 29.4 with additional permanent requirement of the non-commercial wells. In addition, over the well survey information required within 312 of the Indiana Administrative Code 29.42E with the survey must include with the permanent number, the location of the state, with the depth of each of the well oil gas purpose included band of the non-operational wells located within 1/4 mile of the proposed non-commercial well that intersect with the formation produced. Non-commercial well with a non-conforming to applicable space limitation. Application with a non-commercial well with the proposing well location closer within the applicable spacing limitations set forth in 312 of the Indiana Administrative Code 29.13.3 and 29.13.4 that shall do the following provided the following information for each of the well oil gas purpose included wells with the permitted yet with the production well temporarily abandoned staff with the 312 of the Indiana Administrative Code 29.13.4. 32-4, intersecting the formation produced located within 1/4 mile of the gross non-commercial well of the well of the permit number of the well location of the name of the operator and the owner of the well, depth of the severe written notification application of the owner and operator, each of the well, oil, gas purpose with identified on subdivision 1, each of the property owner located within 1/4 mile of the proposed well of the notification request requirements. Section 4 of the notice required within Section 3.2 of the rules should include the following copy of the permit application statement that proposed of the well, except for the well spacing 312 of the Indian Administration Code 2913 with the notice of the operation will resolve the drainage of the adjacent property with the notice of the person with the drill for the well spacing and exemption of the made with the written comments of objection the request for the informal hearing of the 312 of the Indian Administrative Code 2934 within 30 days of the receipt of the notice of drill for the written objection the comments of the request for the informal hearing must be filed. Application shall provide with the proof of the notice required with Section 3 of the Rule of Division submitting with a certified mail receipt with a written statement of the recipient accompanied with a copy of the written notice of the approval and the denial of the non-commercial well permit and exemption for the well spacing unit with a requirement of non-commercial well shall be issued with denied and later within 18 days to serve with the add notification required in Section 3 of the Rule of the Director's issue with the determination following with the informal hearing conducted in accordance with 312 of the Indian Administrative Code 2934 of the decision approved with the denial of the non-commercial well permit in Section Indiana Code 421.5 of the division shall issue the notification decision over the approval of the denial of the commercial well permit application in accordance with 312 of the Indian Administrative Code 2935. Addition issuing of the notice of the permit decision required by the 312 of the Indian Administrative Code 29351 for the division shall issue with the notice of the permit decision each of the person provided notice under the subsection 3 of the rule. Each person who filed with the division written comment objection request for the informal hearing 312 of the Indian Administrative Code 2968. Alright, Rule 8, additional permit requirements for the underground storage facility reserve. Rule 9, additional permit that requires underground petroleum storage facility reserved. Rule 10, additional permit requirements for the geological structural testing well. Geological structural test well application of the rule establishes permits requirement of geological structural test wells in addition to the requirements of 312 of the Indian Administrative Code 29.4. The description of the test intervals. Application of the geological structural test well shall identify with the objective of the test well, but describe the geological, structural, hydrological, stratigraphic intervals tested during the after and drilling of the well construction plan. An application shall include the well diagram showing the following information: hole size, casing size, weight, and depth, and type, and the cement volume and the type. Post-testing schedule. The applicant shall include the schedule following with the length of the time necessary for the conducting testing operation, action testing over the conclusion, testing operation time, either the converting well of the production well of the class 2 well of the plugging and abandoning of the well, approval of the denial of geological structural test well application, decision, approve of the denied geological structural test well permit application is subject to the Indiana Code 421.5. Division shall issue the notice of issues and approve of the denial of the geological structural test well of the permit application with the 312 of the Indiana Administrative Code 2935. Rule 311, the drilling in the cars prone area. Section 1, the section establishes the additional requirement of the drilling with the well, oil, gas purpose with the location identified with the cars prone area with the owner and the operator shall the drill with the well, the drill with identified with the cars prone area with accordance with this rule. Owner and operator shall determine if the well and oil, gas will be the drill with identified with the cars prone area with the after the maps maintained with the division. Well, the drill with the cars prone area with the owner and operator shall with the following with the use of the capable tool dig rig with a rotary drilling rig using air, water without drilling mud to circulate with the cuttings of the drilling with the interval between the surface of the depth of the surface of the casing to be set. Surface of the casing in perpendicular formation is at least 30 feet below the depth of the cars feature with the low circulation zone with the likely encounter base of the review of the logical, geological, oil and gas water well drilling records for well previously drilled within 1/2 mile of the proposed well location. When the previous drilling has not occurred within 1/2 mile of the proposed well location, minimum surface of the casing drill with the shall be in to impervious formation at least 30 feet with the top of the board and the group of the cars with the developed Mississippi age rocks with 30 feet with the Makahoe group of the cars with the developed and Devian and Surian age rocks. The driller shall note with the record of the driller log with the completion report with the depth of any of the areas void with the loss of the circulation zone with the encounter with the drilling with the end the cement with the surface of the casing cement with the basket with the install with the casing with the first with the adjustable with the area void lost circulation zone with the encounter lost circulation material with the common and commonly used cement additive to it should be used with the practice of the reduced cement for the car's feature with the void with the loss of the circulation zone encountered with the drilling below with the surface of the casing with the seat with the owner with the upper dish shall take an appropriate measure that minimize with the cement loss of the car's feature with the file with the set with the intermediate with the casing string with at least 30 feet below with the void of lost circulation with the basket cement basket installed with the first casing zone joint above with each of the area void lost circulation zone is encountered If the method you can carry should be taken with a pump of the minimum amount of the cement necessary to fill with the annulus over the bottom of the void cement should be placed over the surface of the termite pipe casing annulus cement with an interval above the cement basket. Use the lost circulation material with the cement additives along with a combination sufficient of the cement baskets installed with the first casing joint above each area with a void of lost circulation zones encountered. Approval of the denial of the permit application drill with the cars permits and area with the decision of the approval of the denial of the permit application drill with the oil gas strip with the location identified by the cars permits and area with the Indiana Code 421.5 with the division for the issue with the notice decision approval of the denial of the permit application drill with the oil gas strip identified and location identified with the Casperone area with the accordance with 312 of the Indian Administrative Code 2935. Rule 12, annual well field bonding, well fee and bonding. Each owner of the operator must pay with the annual well with a fee based on the number of the wells over the gas purpose of which the owner holds the permit in November each year. Each owner operators must conform with the number of the wells remit with the annual fee during within Section 2 of the Rule Division no later than February 1st of the following year with the failure of the owner of the operator to comply with the subsection of the violation of the cases of the revocation of any of the permanent violation. Well, for the oil and gas purposes include with any annual well fee with the assessment with the until the earlier following with the wells plugged with the well site with the restore with the 312 of the IEA Indiana Administrative Code 2933. Well, is transferred the new permittee under 312 of the Indiana Administrative Code 29410. February 1st each of the year with the owner operator oil and gas purposes must also report the division form to describe the division chain with the mailing address of organizational status. Amount of the annual fee well fee assessment with the division shall assess the annual fee with its 12 with one permit and one of $150, 2 with its 5 permits $300, through 6 to 25 permits $750, 26 to 100 permits $1,500, and 5 more than 100 permits for the $1,500 plus $15 for each permit over 100. Upon required additional annual well fee, if it is a person who has never been granted with a permit over the well, oil, gas under Indiana Code 1437 and is with the article demonstrated pattern violation Indiana Code 1437 of the article of civil penalty is 7,312 of the Indiana Administrative Code 2934 for the previous 2 years, but has failed to pay civil penalty in 312 of the Indiana Administrative Code 2934 4, but it fails to pay an annual fee required in the Indiana Code 1437 and 5 with its rule should not be issued with a permit over the well, oil, gas permit in the Indiana Code 1437 of the article until the person have an acceptable bond with the provided in Section 4 of this rule with the bond is described in subsection A of the additional assessed fee with the annual well fee with imposed Section 1 and 2 of this rule. The bond shall renew until there has complied with the condition of the Indiana Code 1437 and in this article with the permanent 2 consecutive years of the permanent no longer may be any of the conditions section A1 through A4 with the requirement of procedure applicable bond to apply with the substitute with the securities described in Indiana Code 1437.6.2 and Indiana Code 1437.6.4. Any person with a name to the permanent with the issue with the shall issue with the named principal on the bond with the named owner with the operator with the permanent over the principal on the board bond shall be the same. Bond types. The bond type required within section 3 of the rule shall consist of one of the following: a surety bond amount with $2,500 for each of the wells drilled with them produced, cash amount with $2,500 each well with the due produced, with the certified deposit with the principal amount with $2,500 for each of the wells drilled with the produced according with the term within specification provided by the division. The surety bond amount with the wells drilled with the deep and the converted with however the maximum number of the wells under the bond may not exceed the number determined with dividing the principal sum with the bond with $2,500. Blanket bond of $45,000. The number of the wells drilled with the deep and the converted. No surety bond shall be approved unless the issue with the company holding an applicable certificate of authority in the Department of Insurance of the surety bond may executed by an owner and operative principal by surety either of them by an attorney, in fact with the certified power with the attorney attached. Division shall retain the possession of the custody with the collateral deposit with the application until the release and replace with under the rule of the certified deposit that may be assigned with a written stay with the assignment. No over the books federally with the insured with the financial institution issuing the certificate. Waive the annual well fee with the bonding requirement of certain non-commercial well with the respect of the non-commercial well with the real estate with the resident Indiana with the division director may waive the annual well fee with the bond required with the rule to provide with the person following. Submit written proof of the financial responsibility to operate, maintain with abandoned well with one of the division into the agreement to operate, maintain with abandonment well with accordance with the Indiana Code 1437 in this article. A person without owning more than 5 non-commercial well with the Indian shall not be granted waiver under this section. Bond cancellation and surety bond surety when there may not be written notification of the division owner of the intention of the terminated liability of the under of the bond surety delivery of the notification owner with the operative principal server by server to mail with the proof of server the notification to provide with the surety of the division. In 30 days after the receipt of the notice of the subsection A, with the owner and operative of the substitute with the bond with the must discontinue the operations of well coverage with the bond with the plug and abandon of the well in Indiana Code 1437 and then 312 of the Indiana Administrative Code 2933. Substitute with the bond with the file with the owner and operative liable original bond. C, for the if an acceptable surety bond was not filed with the owner and operative of the owner and operative failed with the plug and abandon of the well according to subsection B, surety liability under the bond shall not see for the division shall with the file with the complaint of the revoked with the permitted well for the oil and gas purposes. Indiana Code 4215 within 312 of the Indiana Code Administrative Code 2934 or 5. If the owner or operator failed to abandon with the wells required in Indiana Code 1437 in this article, surety bond must forfeit the division with the principal sum of the bond restrict with the well for the oil gas purpose of the surety may cause the well to be properly plugged and abandoned. Bond forfeiture of the division of the director may order of the bond forfeiture permanent if the secured by the bond is revoked the finding of the division otherwise support of the forfeiture. Bond forfeitures are governed in Indiana Code 421.5 and in 312 of the Indiana Administrative Code 31 bond release. The division shall release for the bond submitted with the pursuing of the rule after each well is secured with the bond plug with abandonment of the well set with the required in Indiana Code 1437 in this article with the term permanent for the order division. Each well secured by the bond converted with a freshwater well with the acceptable substitute with the bond with this file with the owner and operative of the well secured with the bond is transferred from 312 of the Indiana Administrative Code 29410, where the owner and operator is not required to post a bond with the Indiana Code 1437 and 61A or Section 1A of the rule. Rule 13, location of the well drilling unit, well spacing, the well, oil, gas purposes shall not be located 200 feet with the house or the building or other structure except the fences existing time of the permit application with express with the consent of the owner and structure. Exempt of the drilling and the well spacing requirement. Following wells must be exempt of the drilling unit well spacing requirement according with Section 7 of this rule. No commercial well with except for the non-commercial well should be located with it would be caused with the existing commercial gas, coal, methane well be type of the violation spacing requirement of the rule. Coal bed methane well is completely in any of the following void created with the mining out of the coal seam piler inside of the mined out with abandoned the uncontrolled underground connection mine with the gob created with the long wall with the other method of the coal extraction class 2 wells, gas storage observation well, petroleum storage wells, water supply wells, geological structural wells, drilling units and well spacing, vertical oil wells, where wells drilled with the deep into the production oil with either with the Trenton Formation with the Black River, the Formation shell with the Trenton Limestone with the reservoir region. Drill unit shall contain 5-acre lands or more or less. A well should be located 165 feet with the nearest extreme of the boundary line, leaf the production not less than 330 feet from the nearest location. Any of the following same individual reservoirs production over the well and oil gas purpose of the well is drilled with the oil gas purpose of the proposed well with the oil gas purposes for which permits for the have been issued with the well is not yet drilled with the well is drilled with the deep in the production any of the formation not specified in the substrate with the top of which lie with the 4,000 feet with the beneath the strip of the drilling. The unit shall contain no less than 10 acres. The well should be not located less than 330 feet with the nearest external of the boundary line. Leaf of the production notice unit with less than 660 feet from the nearest location any of the following same reservoir production well, oil, gas purpose of the well drilled with the oil, gas purpose of the site with the proposed oil, gas for the permit has been issued with the well is not drilled with the wells drilled with the deep in the production oil with the information on top of the well is equal to greater than 4,000 feet with it beneath the surface. Drilling of the unit shall contain no less than 20 acres, with a subject located no less than 330 feet from the nearest external of the boundary line. Leads for the production unit no less than 660 feet from the nearest location of any of the following same over the production well, oil, gas purpose of the well is drilled with the oil and gas purpose of the site with the proposed well, oil, gas for the permit issue of the well is not yet drilled. Drilling units, well spacing, vertical, natural gas well with the drill with the deep in the production and natural gas with the Trenton with the Formation Black River, the Formation shell with the Trenton Limestone region with the drilling unit shall contain 5 acres of land with the well should be located to 265 with the nearest external of the boundary lease production not less than 330 feet from the nearest location. Following same individual reservoir production well with the oil gas purpose of the drill with the oil gas purpose of the site with the well with the gas with the permit has been issued with but not yet drilled with the well with the deep and with the production natural gas with the sandstone reservoir specified subsection A with the top of which less than 1,000 feet below the strip of the drilling unit shall contain 10 acres of land or more, or less. The well should be not less than 330 feet with the nearest external of the boundary line. Production unit not less than 660 feet from the nearest location following the same levels of the production oil gas purpose of the well drilled with the oil gas purpose of the shed with the proposed oil gas purpose of the permanent issue with the well is jet drilled. for wells drilled and deep into the production of natural gas with the formation, especially for the subsection A with the top of the lies with the 1,000 feet below the strip of the drilling and should contain with the 20 acre with the more or less for the well should be not located with the 330 feet with the nearest external with the boundary line loss with the production 660 feet for the nearest well location any with the following same reservoir with the production oil gas well with the purpose of the well drill with the oil gas strip of the set with the pros well with the oil gas head with the permit issue but the drill with the wells deepen drill with the deep in the production of natural gas any formation temperature with greater than 1,000 feet below the surface of the drilling unit with the 40 acres of land or more or less with the well located with not less than 330 feet with the external of the boundary line lost production 990 feet from the nearest location following in the same reservoir production well oil gas permitted well drilled with the oil gas permitted site proposed oil gas permitted for the permit has been issued but not yet drilled drilling units with the well space with vertical coal bed methanes and with the 4 wells deepened and complete with the converted with a vertical bed methane with the drilling unit should contain 40 acres of land more or less the well should be located with less than 330 feet with the nearest extreme of the boundary line lease production unit with the loss of 990 feet from the nearest location with the following production coal bed methane well with the well drilled with a coal bed methane well site with the proposed coal bed methane well with a wish permit with the issue but the well with not yet drilled with the seam and the coal seams well location exempt from well drilling unit if at the time of the application of the lease of the immediately adjacent of the proposed drilling unit owned with a different operative with the producing well with completely with the same formation located less than the required distance with externally bound line drilling unit with the set forth in section 3 through 5 this rule will be proposed drilling unit may be located closer with the external boundary line drilling that is set forth in section 3 through 5 of this rule no more closer to the distance of same with the well with the common boundary line drilling unit the drilling during the drilling well with the well lost due to the collapsing hole of the casing of the condition of the return of the continue with the drilling impracticable prudently may terminate with the drilling and move the rig up to 30 feet from the permitted location commenced with the drilling operation provided with a notification moving the rig provided with the oil gas inspection within 10 days of the original lost hole is plugged in accordance with 312 of the Indian Administrative Code 2933 with a new application fee for the submitted within 10 days after showing the new location of the well. Approval alternative drilling unit section 7.1.7a if the area larger of the drilling unit specified in section 3 through 5 of the rule under the common ownership of the division the director may approve of the drilling well with greater density with the otherwise permissible the rule under the operative demonstrate with the following proposed drilling pattern with the area common ownership of the control of the reasonable necessary for more efficient recovery with the oil and gas and coal bed methane waste will not occur unnecessary well will not be drilled with the wells maintained with the required distance near external of the drilling unit boundary line now with the common ownership of the control of the specified in section 3 through 5 of this rule wells maintained within the required distance of the other wells adjacent drilling units outside of the area with a common ownership of the controlling producing same formation. Any person interested in oil gas lease for the drilling unit, including pool wide unit with a position of the division direct for the establishment of the alternative of the drilling units, otherwise providing subsection A of the geological engineering character of the reservoir relative with the land survey system specified with the drilling units under section 3 through 5 of the rule position shall include name and address of the position. All owners required record of the oil and gas into the position name with the name and address for each permit record area active of the wells located within 1/4 of a mile of the boundary of the position line. Geological engineering base requesting alternative drilling unit ISO patch for the structural map of the reservoir showing when the productive limit of the reservoir legal land the description of the drilling unit slot demonstrate for the alternative drilling unit will not result in waste and unreasonable drainage of oil, gas, coal bed, and methane adjacent drilling units drilling with unnecessary wells upon acceptance of completion of addition under subsection B of the division director shall include an additional and informal hearing of 312 of the Indian Administrative Code 2934 to consider the request. Approve of the denial of well spacing drilling on units waivers. Decision approve of the denial of the exemption of the drilling unit well spacing requirements under section 2.5 of this rule. Will case exemption under the section 6 of the rule. Alternative drilling unit under section 7 of the rule is subject to the Indiana Code 421.5. Division shall issue for the notice of the 312 of the Indian Administrative Code 2935 of the decision approve of the denial of the approve of the following exemption of the drilling unit well spacing requirements under section 2 of the rule. Well location exemption under section 6 of the rule. Alternative drilling unit under section 7 of the rule. Rule 14 drill unit well spacing directional wells.